Good morning, everybody. Welcome to our webinar, Untangling the Top 10 Accommodation and Leave Knots. I'm Beth West. I'm the chair of the Labor and Employment Department here at Weintraub Tobin, and I'm joined by my colleague, Ryan Abernethy, that you see there, maybe on the screen. We're going to present this material to you today. We hope the material that we provide you helps you untangle these knots and answers questions you have. We've got 2 hours, a lot of material, so we're going to go pretty quickly. This is kind of an overview fundamentals webinar on leaves and accommodation laws. Before we get started, just some housekeeping. An e-blast did go out shortly before the webinar with a copy of the presentation and information for those of you who want to request HRCI or MCLE credits for attending today. For those of you who registered yesterday or this morning, there's a second email blast that's going to go out after the presentation that will have a link to the recording of the webinar, and it will also include links to our labor and employment law blog, as well as our firm's COVID-19 resource hub. We are not going to use the chat function today or the raise hands, only because we just don't have time to address things as we go, but we will use the Q&A function. So if you have a question, go ahead and type it in the Q&A box. And if we have time at the end of the webinar, we will address some of those questions. Also remember that your question may be answered during the presentation. So with that, we're going to get started. I believe I have control of the slides, so here we go. Do I have control of the slides? I have Ramona also in the background here, who is helping us with logistics. Okay. It says I'm reviewing the slides, not that I have control of the slides. Give us a second here. All right, now we should be able to do it. There we go. Okay, so we're off and running. So the top 10 knots that we're going to untangle today with the information we present. Which leave and accommodation laws apply to your company? Which employees are eligible under the different leave laws? What rights and benefits does each leave or accommodation law provide an eligible employee? What's the difference between a statutory leave of absence and a leave of absence as a form of reasonable accommodation? They're not the same. What is the difference between a statutory leave and benefits under SDI and PFL, right? State disability is not a leave statute. How do certain leaves interact and maybe even overlap with other laws? What documents are employers required to provide employees, and what records should they maintain? What medical information or other documentation can an employer request from an employee to support the leave? What reinstatement rights do employees have after leave? And when can an employer, in certain situations, refuse to reinstate an employee, or maybe even terminate employment when an employee is on or finishing leave? So these are the knots or the questions we hope to provide information on. Of course, this is an overview course, not an in-depth analysis of every statute. So the various leave laws and accommodation laws that are part of this whole puzzle, this complex web, are FMLA and CFRA. Those are the big family and medical leave laws under federal and state law. PDL, which is the pregnancy disability leave law in California. The ADA and FEHA with respect to disability accommodation under federal and state law. The Workers' Compensation Act, many other statutory leaves of absence that we will touch upon, and then other wage replacement laws like SDI and PFL. All of these can come into play when you have an employee who needs to be absent from work. Okay, So here we go. We're going to start with the big ones. Family and medical leave under the FMLA and CFRA. What are they? FMLA is a federal law. CFRA is a California law. FMLA stands for the Family Medical Leave Act. CFRA stands for the California Family Rights Act. And it entitles an eligible employee up to 12 weeks of unpaid leave in a designated 12-month period with right of reinstatement, except in certain circumstances under FMLA. FMLA also contains a provision for military caregiver leave that has a different leave entitlement of 26 weeks in a 12-month period. Who are covered employers under the law? In the US under FMLA, it's only larger employers with 50 or more employees within a 75-mile radius. CFRA used to be the same as that, but as of January 1st, 2021, the law changed and CFRA applies to employers with 5 or more employees, and there is no 75-mile radius requirement. Eligible employees under both laws, pretty consistent. They have to have worked for the company for 12 months of employment, and that 12 months does not have to be consecutive. So if they had a break in service at some point but came back and total service is 12 months, then they would meet that requirement. And then they have to have worked 1,250 hours on the job within the previous 12 months right prior to wanting to go out on the leave. There's a caveat here for California law under the CFRA. If an employee is not eligible for CFRA at the start of some other leave, for example, if a pregnant woman goes out on pregnancy disability leave at 11 months of service, then the employee can meet the 12-month requirement for CFRA once, the next month that she's out, the 1 month that she's out on PDL goes by and she has been employed for 12 months because when she goes out on PDL, it's not a break in her employment. She's still employed, so therefore she meets the 12 months. And when she's done with PDL, she could potentially have baby bonding leave under CFRA. Okay. It's important that employers designate the 12-month period that the 12 weeks of leave can happen within, because a lot of times we see employment policies where it just states the law. Eligible employees can take 12 weeks in a 12-month period, but they don't define what 12-month period they're talking about. The employer has left that language out. And the statute gives the employer to choose the method to measure the 12-month period. It can be a calendar year. It can be based on the employee's anniversary date of employment. It can be what's called a rolling forward year, which starts from the date an employee first uses any FMLA or CFRA leave, or it could be a rolling back 12-month period that's measured from the date employee uses any FMLA, CFRA leave and looks back with respect to prior use. And the reason why it's important for an employer to choose the method is that the case law interpreting FMLA and CFRA says that if an employer doesn't state the method, then the employee who takes FMLA or CFRA leave gets to choose the method that's most beneficial to them. And I can tell you, we very rarely, if ever, recommend that you use a calendar year method of measuring the 12-month period, because that could result in an employee going out at the end of 1 year for 12 weeks. And as soon as January 1st comes around, they're taking another 12 weeks. So they've been out for 24 weeks. So usually we recommend one of the other 3 methods of measurement. And the CFRA regs also have a provision that if you're going to change the method at some point, you're updating your employee handbook or something, you have to give 60 days notice of the new 12-month measurement period. Okay, why can employees take leave under FMLA and CFRA? Pretty consistent between the 2 statutes, but we'll point out the differences. So employees can take leave for baby bonding with either a newborn child, an adopted child, or a foster child. They can take leave for family care. That's for a child, spouse, parent, registered domestic partner under CFRA, child of a registered domestic partner under CFRA, who has a serious health condition. And CFRA was also amended as of 2021 to include the grandparent, grandchild, and sibling. They can also take leave for their own serious health condition. They can take leave under FMLA for what's called service member family care, which is serious to a family member with a serious health condition, but it's a family member whose serious health condition has some connection with military service. And that's the one that allows them actually to take 26 weeks, not just 12. And then qualifying exigency, also related to military service, originally was only available under FMLA, but when the CFRA was amended as of January 2021, qualifying exigency is also available under CFRA. So let's talk about these military type leaves. As I said, military caregiver leave permits the employee to have 26 weeks in a single 12-month period. And unlike other forms of leave under FMLA and CFRA, where the employer can choose the 12-month period to measure the 12-week entitlement, when we're talking about military caregiver leave, the 12-month measurement period always starts on the day the employee takes this kind of leave. That's where you start measuring the 26 weeks. And then qualifying exigency, it's 12 weeks in a 12-month period, and the measurement of the 12-month period is the employer's chosen form of measurement. Qualifying exigency is when you have an employee who has a family member who is in the armed forces or some National Guard or Reserve position, or gets deployed to a foreign country on behalf of the government. And the reason for the leave is that things come up when that happens, right? The employee who has some family member, here it's spouse, domestic partner, or a parent or child, they need to take care of some things before that person either goes into service or is in service or returns from service. And so what are some of those exigencies? Military events and activities, rearranging childcare and those kinds of things, taking care of some financial and legal activities before the person leaves, making sure, right, that your employee is on the bank account when it used to be just his or her partner that was, or maybe they're going to go see a lawyer and get their wills done before the person goes overseas or somewhere. Counseling, rest and recuperation. Maybe the person on leave comes back, there's some time that's needed for rest and recuperation, and other post-deployment activities 90 days after the military member returns. And then any other events that maybe the employee talks to you about and says, this is something that we need to get done because my family member is being called up to duty, and you agree to allow that person to take some qualifying exigency leave. Military caregiver leave, this is the 26 weeks. So again, it's very similar to taking care of a family member who has a serious health condition. But really what it is it's a health condition that stems from or was exaggerated or exacerbated by military service. And I've got a slide here where we're going to talk about serious health conditions. For serious health conditions for military caregiver leave, this is what the regs define it as. It's injuries or illnesses that were caused in the line of duty or maybe existed prior to the person going into active duty, but then was aggravated by that service. And so that's for an active military member, but it also protects veterans. And it's similar, the injury or illness was incurred by them while they were in the line of duty or was exaggerated because of their service. And it manifested itself before or after they became a veteran. So essentially, without getting into the weeds on the difference here, if you've got an employee who has a family member who's a military service member or a veteran of the military, and they have a serious health condition that has some relation to their service in the armed forces, then it's very likely, if all other eligibility requirements have been met, that your employee could take time off under FMLA, not CFRA, FMLA, if needed to take care of their family member. Serious health condition for all other FMLA, CFRA leave for taking care of family members, not military service members, or the employee's own serious health condition is defined as follows. And I'm just going to say, I'm giving you these definitions here, but I want you to know as employers, we should not get caught up in the weeds of trying to determine if something is a serious health condition under the statutes. We should use the tool that the statutes give us as employers to obtain medical certifications from healthcare providers and have them tell us whether the employee or the employee's family member has a serious health condition. And Ryan is going to talk to you about medical certifications a little later. But there are specific definitions for serious health condition. And what I find sometimes is that employers will just take a doctor's note, they don't get a medical certification, and they designate an employee as FMLA covered when really their medical issue does not meet the definition of a serious health condition, right? It's not an injury or illness impairment that involved inpatient care at a hospital with subsequent treatment. It didn't involve incapacity for a period of 3 days and then follow-up treatment by a healthcare provider or continuing treatment. And it's not a chronic or permanent long-term condition, i.e., cancer or Parkinson's disease or something like that. Now, there are some slight nuances, some slight differences in CFRA's definition of serious health condition. As you saw, one of the qualifying factors was that if the employee or the employee's family member was inpatient care in a hospital or hospice, that means inpatient, staying overnight for 1 or more days. That's the FMLA. CFRA says that inpatient means that the healthcare provider formally admits the person with the expectation that they're going to stay overnight, that they're going to be inpatient. But if they happen to be discharged at midnight and don't stay overnight, they'll still satisfy the definition under serious health condition for inpatient care. And then, if you recall, one of the required qualifying elements is if they weren't an inpatient, if they were incapacitated for more than 3 days and then had 2+ treatments by a healthcare provider or treatment by a healthcare provider with a regimen of continuing treatment. What CFRA says is that incapacity merely means, without having to meet all those expectations, is the employee's or the family member's inability to work, attend school, or perform other regular daily activities because of the serious health serious health condition, or any treatment they're receiving for it, i.e. chemotherapy, or recovering from a serious health condition. Now, most people forget, because when we say that an employee can take time off for the serious health condition of their child, usually that means their minor child, right? Their child who's under 18 that they have a responsibility to care for. But there is the possibility under FMLA that an employee could take time off to care for an adult child. And it's a little different. It's not just that the adult child has a serious health condition, but other factors have to be met. And the DOL some years ago issued guidelines on when an employee can take this leave. And here are, the requirements. The adult child has to have a disability under the ADA, and that disability results in the adult child being incapable of self-care. And then the disability also has to qualify as a serious health condition under the FMLA. So it has to meet one of those eligibility factors we just discussed. And because that the adult child is in need of care and the employee needs to take time off to provide that care. And so what the DOL did was say for employers and even the employee who wants to take the time off to determine are they qualified, they came up with kind of a formula where they said incapable of self-care, the adult child's inability to provide him or herself care, requires assistance or supervision in 3 or more of what's listed here. And they're titled as activities of daily living or instrumental activities of daily living. And so if the adult child is unable to do 3 or more of these as listed, and they have a disability that's a serious health condition, then the employee could qualify under FMLA to take up to 12 weeks to care for them. You can, just like in any other situation, get a medical certification to support this. Okay, it's very fact specific. All relevant factors are evaluated. That's really kind of true for most care for family members. Also, one important element to remember under both FMLA and CFRA is that when an employee is eligible for FMLA or CFRA leave, it doesn't have to be taken all at one time. So the 12 weeks can be taken in incremental periods, right? What's called intermittent leave, or sometimes they take a reduced schedule leave for a period of time. There are certain rules if that happens. If they're taking intermittent leave for the purpose of baby bonding, to spend time with a child that's been recently born, adopted, or placed in foster care, then the statutes say that that leave, even if taken intermittently, has to be concluded within 1 year. Under CFRA, intermittent leave can be taken if the employee or the family member is incapacitated and unable to perform the essential functions, even if they're not receiving treatment. That's the nuance I talked to you about previously on what incapacity means under CFRA. But one other thing to remember is that both the regs under FMLA and CFRA say intermittent leave is really only appropriate when it's medically necessary, when a healthcare provider says it's medically necessary, not just desired by an employee, but necessary. And that's overlooked sometime. Again, employers are just accepting the doctor's note without explanation of the necessity that the person be out, 2 weeks each month for the next 6 months. If, however, you find yourself in a situation where an employee requesting intermittent leave and it's, supported by medical certification, sometimes that can be disruptive to operations. So the regs do say that you can, if it's possible, to do some temporary transfers of these employees to different positions. They can't suffer any loss in pay or benefits. But if there's another position at the company that would better accommodate kind of this intermittent or reduced schedule leave, you can transfer the person to that alternate position during the pendency of their intermittent family medical leave. Okay, let's talk about some differences about FMLA and CFRA. I keep putting out here in bold, January 2021, because that's when we had major revisions to the California Family Rights Act. And so it's different. If there's anybody on this webinar who is continuing to administer CFRA leave exactly like FMLA leave, you need to reevaluate your policy and your practice of administering these leaves, because they're not entirely the same. So CFRA now says that if you have 2 employees who are parents, that work for you, each of them gets the 12 weeks of baby bonding leave under CFRA. Under FMLA and previously under CFRA, employers for this kind of leave, for baby bonding, were allowed to require them to split it or manage it, not split it exactly even if they didn't want, but they needed to utilize the 12 weeks together so that you didn't have 2 employees who were each out for 12 weeks. Well, under CFRA, they now have that entitlement. The other big difference that came out of the amendments to CFRA is that unlike FMLA, where if you have a key employee who needs to take FMLA leave, in certain circumstances, you can deny reinstatement to them if they meet the definition of key employee because it's too difficult for you to hold that position open. That is no longer an option under CFRA. There is no key employee exemption to reinstatement. And then the biggest, probably the biggest revision to CFRA was that it now applies to small employers, right? I mean, it used to only apply to 50 or employers with 50 or more employees. Now, you know, small little companies that only have 5 employees, 5 or more, are subject to CFRA. But what the legislature thought would help in this situation by applying it to these small employers, which I don't really think it's having that effect, is that it also instituted this mediation program through the DFEH. All that does is that if there's some dispute down the road between the employer and the employee with respect to whether they got their CFRA leave or it was interfered with or they were retaliated against, is that prior to a lawsuit, there's the option for the employer to request that the dispute be mediated with the DFEH. So that's just dealing with disputes later, but it doesn't deal with the fact that small employers now are having to accommodate and have employees absent for potentially 12 weeks because they're covered under the leave entitlement under CFRA. Some other differences, this actually just went into effect January of this year, is that CFRA was amended so that the definition of parent for a family member that an employee can take CFRA leave for if they have a serious health condition includes parents-in-law. So not just the employee's own parent, but their spouse's parent. And it made some modifications to that mediation program as well. I listed here, either party can request mediation. And if it turns out that the DFEH did not provide notice of the right to mediate and an employee sues an employer, the employer can go and seek a stay of that lawsuit on the grounds that they did not receive appropriate notice of their opportunity to mediate. That's unlikely going to happen. DFEH has policies and procedures in place to issue those notices of mediation. Some other differences between FMLA and CFRA. The DOL issues a medical certification that employers can use. So does the DFEH. And I will tell you that employers in California should utilize the medical certification for CFRA or the one from the DFEH, not the one from the DOL, because there is a restriction on some information we're allowed to obtain in a medical certification in California that is not recognized in the DOL form. The other important distinction is under CFRA, employers cannot contact a healthcare provider to do what's called complete the medical certification or to ask questions because the information in it is insufficient. You can do that under the FMLA, but the CFRA says you can only contact the healthcare provider to authenticate it, which means you can contact them to verify that they in fact completed it. So that's a big difference, because under the FMLA, you know, if an employee turns in a medical certification that's mostly blank, or has information that's not really helpful and you have questions, the FMLA says that somebody from the company, the employer can contact the person who prepared the medical certification and ask what, you know, the responses are to the missing information or seek clarification on insufficient information, as long as it's not the employee's supervisor doing it. But you can't do that in California. And so very likely, if a leave qualifies for both CFRA and FMLA, then, or only CFRA, then the employer can only contact a healthcare provider to confirm that that healthcare provider, in fact, completed the form. The other difference with respect to intermittent leave for birth of a child, we know that that leave, if they're going to take it intermittently, has to be concluded within 1 year of the birth, adoption, or placement of the foster child. Under FMLA, intermittent leave also should be in minimum durations of 2 weeks, right? Not a day here, a day there, week here, a week there, but 2-week increments. The CFRA also says 2-week increments, but it says that an employer has to grant, if an employee requests, to provide leave of less than 2-week duration on at least two occasions throughout that year. So if somebody says, I just need to take next week off, my newborn's childcare provider is going on vacation and I have no childcare and I want a baby bond and take care of my child, they could probably qualify for this 1 week of baby bonding leave if they haven't already exhausted their CFRA leave for the 12 months. Some other differences, the requirement to use paid time off concurrently with any FMLA or CFRA leave. Under both statutes, the employer can require the use of vacation time. Under FMLA, an employer can also require the use of sick leave, and that's regardless of the purpose of the leave, no matter why the employee is out on FMLA. But under CFRA, you can only require the use of sick leave concurrently with CFRA leave if the employee is out for his or her own serious health condition. If they're out for the serious health condition of a family member, then the employee and the employer have to agree to the employee using accrued sick time. And then, of course, there is this limitation that if you do have an employee out and they're receiving disability payments, you can't require they start using their accrued vacation, PTO, or sick time until after they've received those disability payments. Okay, pregnancy, big difference between FMLA and CFRA. FMLA treats it as a serious health condition, pregnancy and pregnancy-related conditions. CFRA does not, and that's because we have a whole different statute, the Pregnancy Disability Leave Statute, which Ryan is going to talk to you about later. And then registered domestic partners, they are not recognized under FMLA, even though same-sex spouses are. But CFRA recognizes both domestic registered partners and same-sex spouses. And this difference could, result in one of those situations where an employee actually is entitled to more than 12 weeks of leave under the two statutes in a given 12-month period. Because if they happen to take leave under CFRA to care for their sick registered domestic partner, that doesn't count against their FMLA bucket of 12 weeks. And so they could take 12 weeks under CFRA to care for their registered domestic partner. And then let's say, a month later, they adopt a child or they themselves get sick, they may have an entitlement for another 12 weeks under FMLA. Okay, we're going to turn it over to Ryan. He's going to talk about medical certs.
Thank you, Beth. Oh, here we go. I'm getting control of the slides. Great. Yeah. So like Beth has already mentioned, it's wise for employers to seek a medical certification when someone has alleged a serious health condition that requires leave under the FMLA or the CFRA. And, again, this is to establish things like whether there actually is a serious health condition, to what extent is this leave required. And this slide kind of outlines some of the things we'll be going over here shortly. But first and foremost, there's a ticking clock here as soon as an employer receives a request for this type of leave in order to seek certification, and it's within 15 days is that time period when an employer can seek a medical certification from a healthcare provider. And there's two separate standards I'll be addressing, and you'll see you can ask for more information generally when you're dealing with an employee's their own health condition versus their family member. There's a few more privacy rights that these statutes kind of recognize, and there's less information you could typically obtain, including there's other, you can obtain a second opinion or a third opinion for an employee's own serious health condition where that isn't going to be permitted or any limited circumstances for an employee, or sorry, for an employee's family member. So first, let's establish who can complete these medical certifications that we'll be submitting to qualify these employees. And a healthcare provider is broadly defined under these statutes. And broadly defined is a phrase I'm going to be using a lot here today, because you'll see there's these rights are very broad, generally speaking. And in this case, the healthcare providers, you could see this list of folks who qualify and the types of positions that would qualify, everything from podiatrists to dentists to chiropractors. These are the types of people who can provide this type of certification. And then this is going back to what type of information we could seek regarding an employee's serious health condition. And that includes information like the date that the serious health condition occurred, when it commenced, the probable duration of the leave that's going to be required, the employee's ability to work generally, and their incapacity from working. Sometimes it requires a full leave. Sometimes there's accommodations that can be required, that can be requested. And again, the ability to perform the essential functions of their job. So because of this, this is one of the reasons why it's so important to have a detailed job description. In addition to, that's good just to have for many other reasons. What an employer doesn't want to typically be doing is creating a job description for the first time when you receive these medical certifications. For obvious reasons, you want to make sure this is clearly established. There's no debate that what you're putting on this list are the essential functions of the job. And this can include things, it's typically wise to include things like that, physical requirements, whether it's standing for a period of time, sitting for a period of time. If it requires picking up things, this is why it's helpful to include that in those types of job descriptions. Because don't assume that the healthcare provider is going to understand what the essential functions of the job are just because you've listed the title, right? Because that could vary significantly from company to company. Okay, and now going back to the different type of leave request, which if someone's taking leave to care for their family member, the type of information you could seek is more limited. You could still find out, for instance, when the need for the leave commenced, but obviously to what extent are they incapacitated is going to be less important to whether this employee needs to work at all. And the CFRA broadly defines what type of leave an employee can leave to take care of a family member. It's anything that warrants participation by the employee. It includes things like providing psychological comfort and arranging for third-party care for the family member. So again, your employee can take off leave to fulfill these types of family obligations. Beth mentioned this. There's the DFEH has their own kind of pre-made certification healthcare provider that form that they created, and this one is wise to use versus the Department of Labor's because of the reasons Beth has already mentioned. There's certain rights that a California employee has that other employees in other states don't necessarily have. So this is the one to use. No need to reinvent the wheel and try to create your own. That's a good form they have there for you. Now, a big, I guess, warning, a landmine, and there's many landmines in all of this process. We call this untangling the web of leave laws because, we're going to cover several statutes and other things. And you could kind of think about circumstances where one single leave request could trigger an inquiry into every one of these areas of law we're going to talk about. And here's one of those potential crossovers where the employer needs to get information, but there's also this thing called GINA, the Genetic Information Non-Discrimination Act, where employers cannot seek or request any type of genetic information from any employee or individual or family member of an employee. And so it's important to carve that out, make sure you specifically say you're not seeking that information, any of these requests. Because it's if that information is in your lap, that's going to be difficult. So make sure it's very clear in the certification request that you do not want anything like that. And this is the California Confidentiality Medical Information Act. I'll just leave this up here. You should all have this already. I'm not going to spend too much time on it, but essentially you need to obtain authorization from the employee first and provide them with certain disclosures about what type of information you'll be seeking in this medical authorization. And, the fact they'll be able to get a copy of it. and the type, and and various format requirements here are included as well. Now, for those of you who don't know what incomplete or insufficient means, we've defined that here for you very clearly. But sometimes we get these medical authorization certifications back, and there's a box hasn't been checked, a piece of information hasn't been completed. That makes it impossible for the employer to make the determination as to whether this employee qualifies for the type of leave. Also, it can be insufficient. The descriptions that you obtain back from these healthcare providers, they're not always skilled at identifying, or sometimes they get a pile of these, and you don't have the clearest picture, and the employer's kind of left there with a question mark over their head on how to treat the leave request. In these circumstances, the employer has a right, has to give the employee the right to cure. So according to the Department of Labor, the employer shall provide the employee with written notice stating exactly what information is necessary to make the certification complete, right? What was unclear, what was missing. And then the employee has 7 days to cure any of those deficiencies that appear on the face of the medical certification. For the case of employees, the employers can seek a second and third opinions in certain circumstances. So if the employer has received a complete and sufficient certification, but has a reason to doubt that it is valid, the employer may require the employee to obtain a second medical certification. The employer can choose their own healthcare provider to provide the second opinion, but generally the employer can't select a healthcare provider who it employs on a regular routine basis. If the second opinion differs from the original certification, the employer may require the employee to obtain a third certification from a healthcare provider selected by both the employer and the employee. So that makes sense. It kind of this volley back and forth. You use the employee certification. If that's questionable, you get your own. And if they conflict, you kind of get this jointly selected healthcare provider to provide a third opinion. And the opinion of the third healthcare provider is final, and it must be used by the employer. And that, I guess that cuts both ways. And there's certain circumstances where the employer might need to obtain recertification. And this includes instances where, obviously a lengthy request, or where circumstances seem to have changed, right? Where you have reason to believe that some information you've received is cast doubt upon the employee's stated reason for the leave. Or again, the employee has requested an extension of leave, which is the most common situation you see. You get a leave request at the expected return date, then you get another one that pushes it out further. So you can recertify, send out the same certification again, and obtain that information. So in all cases under the FMLA, an employer may request recertification of an ongoing medical condition for every 6 months. So that's a bare minimum. An employer will have that option to seek that sort of recertification. There's also something that we call the Friday and Monday phenomenon, where some employers may have noticed that employees' immune systems seem to become more compromised at a much higher frequency on Fridays and Mondays, which happens to create more 3-day weekends. And the Department of Labor recognized this as well. And in 2004, they issued an opinion letter that said if the employer notices this pattern of Monday and Friday absences, this can in some instances be sufficient to cast doubt upon the employee's stated reasons for the leave, and could be reason to seek further certification. So those types of patterns, the types of evidence. Sometimes you get the question is, well, what type of information can we use that could cause us to question the validity of the employee's current leave and need for it. This is one of them, but there's a lot of case law on this. It's why it's always wise to seek, an opinion from an attorney if you have a specific instance that you're not sure about. And with that, I think we'll turn this back over to Beth.
Thank you, Ryan. I think I have control of the slides. Okay, we're going to talk a little bit more about FMLA and CFRA, and then we're going to jump into other leaves and other topics. But let's talk about what are the employer's notice requirements under these statutes. There are three main notices that are required to be utilized when dealing with an FMLA CFRA leave. The first one is really just the general notice that covered employers under the statutes have to provide employees. It gives a description or a summary of what FMLA and CFRA entitlements are. This can be done in an FMLA CFRA poster. There is a requirement that if you have an employee handbook and you are an FMLA covered employer, you should have an FMLA policy in your handbook. The DFEH also has some publications with respect to CFRA that can also be provided to employees. But this is a general notice requirement, not a notice that you give once an employee's made a request. This is to let your workforce know that you are a covered FMLA and or CFRA employer, and you know what that means with respect to certain leave rights if an employee becomes eligible. Then there's something called the eligibility and rights notice, and both statutes also require that this be provided when we're dealing with a given situation with an employee who may need or has requested time off for something that could qualify under either statute. And there are time limits with respect to providing this notice. You're supposed to get it to the employee within 5 days after they request leave or after you have some sort of knowledge that they may need leave that qualifies under FMLA CFRA. And again, with this, the intent of this notice, the purpose of it is to kind of summarize, what are the leave entitlements under FMLA CFRA and what does the employee have to meet to qualify and be eligible for it? What are the restrictions, and so forth. So this needs to be given once an employee requests leave that you believe qualifies as FMLA or CFRA, or you are on notice that they may need it. Then the other form of notice, or really kind of documentation, is called the designation notice. And again, there's a time limit. The laws say you need to get this to the employee within 5 business days after receiving enough information to determine if they're qualified for FMLA or CFRA. But don't forget that if you have an employee who requests leave and you determine they're not qualified for FMLA or CFRA, let's say, for example, they haven't worked 1,250 hours before they're going to take the leave, you still have to give them this notice, right? And what you have to do is explain to them why they're not qualified. And, the notice forms, DOL publishes some, it will have a provision there, as to why you're not qualified because you didn't work 1,250 hours. Also, you can provisionally provide designation pending receipt of the medical certification as well, so that you can get enough information to make the determination whether the employee is qualified for the leave. And so these three are, statutorily required. And I hate to say, but I have a number of people who contact me on leave issues and really have no awareness of these notices and are not going through the proper notice and designation procedures. Yeah, so here's an interesting legal issue that came up with respect to designation of FMLA leave. And this happened, a few years back, but it hasn't been entirely resolved. So, as I said, it's a statutorily required notice that you designate leave as FMLA leave once you know that the leave qualifies as FMLA. And here it is right from the Code of Federal Regulations, Section 825-301. Once an employer has acquired knowledge that the leave is being taken for FMLA qualifying reason, the employer must designate the absence as FMLA. CFRA has a similar provision. We got this case out of the Ninth Circuit a couple years ago, the Foster Poultry Farms case, where the employee gave information to the employer that clearly informed the employer that the reason she needed to take leave was FMLA qualifying, but the employee didn't want it to be designated as FMLA leave. And so the employee said, no, I want to save up. I want to just use my vacation. And then I want to save up all those 12 weeks so I can use that later. And the whole issue became whether the employer properly or improperly designated the leave, because the employee then said she was shortened FMLA leave in the future. It goes all the way up to the Ninth Circuit, and the Ninth Circuit says that an employee can decline FMLA leave and use paid leave instead, even if the reason for the leave qualifies as FMLA. Well, that caused some confusion in the legal community, to say the least, given the strict interpretation of the FMLA statutes and regs. So then in 2019, the DOL issues an opinion letter that is in complete conflict with the Ninth Circuit's case. And really what the DOL did was interpret the clear language of the statute and the regs, and laid out in the opinion letter again that an employer is prohibited from delaying the designation once they have enough information to know that it qualifies, and that neither the employee nor the employer can decline FMLA protected leave if the leave qualifies. So the employer may not delay designation, even if the employee would prefer that the employer delay the designation. And so now we have these two conflicting pieces of authority, and not to get into kind of legal precedent and what takes, what trumps what, but, the DOL is a regulatory agency. The Ninth Circuit is a federal court of appeal. And usually federal court of appeal decisions, are precedential if they're published, and they do trump regulatory opinions. So what we have in the Ninth Circuit, which covers California and some other Western states, is a different standard than is being applied throughout the rest of the country under FMLA designation. And this difference, this conflict, has not yet been resolved. My recommendation to any of you who are in a situation where an employee needs FMLA leave, qualifies for FMLA leave, you have enough information that it should be FMLA leave, and you're prepared to designate it. If they push back and say they don't want to start using their 12 weeks, consult with legal counsel before you make a decision to designate or not. Okay, we're going to talk about benefits and reinstatement, and then we will go on to other areas. Under both of these laws, the employer has a duty to continue health benefits on the same terms and conditions as was in place before the employee went out on leave, and to continue those for a period of 12 weeks. However, as Ryan's going to talk to you under PDL, there's also an obligation to continue health insurance benefits. There didn't used to be, but the law was revised some years back that made that clear. So for an employee who takes PDL and CFRA leave for baby bonding, 12 weeks of continued health care could be extended quite some time, up to a maximum of 7 months, actually. If you contribute to the premiums, the employer, you have to continue to do that. However, if the employee has an obligation to make some contribution for his or her healthcare coverage, a certain percentage, or to cover dependent family members who are on the plan, they are obligated to continue to do that during leave. And what's important in part of that designation notice and other communications to the employee when they're going out on leave is to let them know, you still have this obligation to pay your share of the premiums. It's not going to happen through payroll deductions if you're not being paid while you're on leave. Therefore, send in your check, by such and such a date each month to this person at the company. There are some provisions in the regulation that say, if you continue to cover the costs of health insurance while an employee is out on leave and they fail to return, there are some provisions that allow you to potentially recoup what you paid to continue that health insurance, but there's also exceptions for your ability to do that if they're unable to return because it's, they're still suffering from a serious medical condition. So again, if you find yourself in this situation, it's kind of tricky. I would work with legal counsel. Okay, both statutes have reinstatement rights. There are little differences I mentioned a little earlier between the two, but essentially the employee coming back from FMLA or CFRA has the right to be reinstated to the original or an equivalent job. However, they have no greater rights to continued employment than they would have had they not gone out on the leave. And so if it is a situation where an employee goes out on an FMLA leave and all of a sudden you're going through a major reduction in force because the economy is tanking and you're eliminating positions, if they had been eliminated, had they continued to be employed, the law does permit you to move forward and put them on the reduction in force list and eliminate their position even though they're on leave. This is very nuanced. Again, as you can imagine, you got to have all your ducks in a row and make sure you're not choosing them because they were out on leave. There could be an inference that that was your motivation. And so I would, again, work with legal counsel if you're going to eliminate a position and terminate employment on that basis. If the original position that the employee was in doesn't exist anymore, you just eliminated it, but you are going to return them to an equivalent position, and again, this should be done on a limited basis. The courts have essentially said equivalent has to be equivalent, in pay, benefits, working conditions, duties, geographical location, effort, so forth. Okay, as I mentioned earlier, there's one exception to reinstatement under FMLA. It no longer exists under CFRA, and that is for key employees. And a key employee is somebody who is among the highest paid 10% of salaried employees in the company within a 75-mile radius of their work site. And if you're going to deny reinstatement to them, you can't wait until the 12 weeks is up and then tell them. You have to decide, do the evaluation and make the determination that they're a key employee when they're going out on leave. And you're going to be looking to see, would it be a substantial and grievous economic injury to hold the job open, right, for them? And if you determine that, you have to notify them that they're a key employee at the time they request leave, or at least shortly after they're out on leave if they've already started, so that they can decide, do I want to continue with this leave and risk not having a job? Or do I not want to take the leave after all? Which, it's kind of a tough position if they're out for a serious health condition for themselves or a family member. But you've got to go through this process so that they're fully informed that they don't have reinstatement protection if they go forward with the FMLA leave, okay? And in California, if the leave also qualifies as CFRA leave, you can't utilize this process. What about fitness for duty releases and exams when somebody's coming back from a FMLA or CFRA leave? You can ask for a fitness for duty release to return to work if you uniformly require that fitness for duty for employees in similar situations. An employee who's been out because of a workers' comp injury for a while, an employee who you accommodated because of a medical issue for a couple of weeks, you want a fitness for duty. You can ask for a fitness for duty when an employee has been out for their own serious health condition on FMLA or CFRA. If they've been on intermittent leave, you can only request a fitness for duty and within, this kind of 30-day cycle, if you've got safety concerns about their ability to safely perform the functions of their job. So those are fitness for duty certifications. An employee who's out on FMLA and CFRA cannot be required to undergo a fitness for duty exam as a condition to return to work. That is a violation of both FMLA and CFRA. And so you could place the person back to work, maybe with a fitness for duty release, And then if you have credible information once they're back at work that there are issues with their ability to perform the job or the essential functions because of some medical issue, or to do it safely, then we're now going to evaluate whether we can do a fitness for duty exam under the ADA and FEHA. And you're going to have to comply with those standards, which means it's got to be consistent with business necessity, and job related, not just some suspicion with respect to, whether they can safely perform the job or not. This is kind of an involved process. It requires a very fact-specific analysis. Again, it's got to be something more than suspicions or beliefs that the person can't safely perform the job. Okay, if an employee returning from FMLA and CFRA comes back, but they're unable to perform the essential functions of the position, there's no continuing obligation under the FMLA or CFRA with respect to their ability to perform the work. But it does kick us into reasonable accommodation analysis under ADA and FEHA, which Ryan is going to talk about later. And so, one of the questions is, can I, they're done with FMLA and their doctor says they can come back to work, but they've got this other medical issue that may impact their ability to perform an essential function. Can I just force them to stay out on FMLA? I don't want them to come back and have to figure out what to do because they have this restriction. No, you cannot do that. If a doctor has released them from FMLA or CFRA leave, they don't need to be out for their serious health condition anymore, but they have a disability or medical condition that impacts their ability to work. You can't force them to just stay out on leave. You have to go through the interactive process, do the hard work to see what their restrictions are, how it relates to the essential functions of their position, and then evaluate in a good faith interactive process whether you can provide a reasonable accommodation to help them work without creating an undue hardship for the company. And again, Ryan will talk more about that. Okay, lastly, the last thing on FMLA we want to talk about is that for exempt employees, this is not a wage and hour seminar, but for exempt employees, we all know that the fundamental kind of premise is that they're not time-based. They don't keep a time clock, and we pay them a set weekly salary regardless of how many hours they work in a day or week, and we can't make time-based deductions from their salary or we risk their exempt status. There is an exception built into the statute in FMLA that says if you have an employee under an intermittent or an exempt employee under an intermittent or reduced schedule FMLA leave, you can, during that period, make some time-based deductions from their salary, that correspond with that reduced schedule or intermittent leave during FMLA only, without risking their exempt status. Okay, we want to just tell you a couple of things about what courts are saying in relation to FMLA and CFRA leave. This dealt with absenteeism rules. And what happened here was that the company had a absent demerit system that, if people were absent or tardy so many days in a time period, they would get demerits. And the system provided that each consecutive day of work with good attendance, right, no absences, then a former absence demerit that was on the books would be removed from their total absences. And so this employee goes out on CFRA leave and he's got 2 absence demerits on his books. And while he's on leave for more than 60 days, the employee does not clear those 2 demerits. What essentially the employee does is just kind of freeze, status quo, and doesn't count his 60 days of CFRA leave with respect to clearing the demerits. And he sued, saying that the failure to count the days that he was on CFRA leave when calculating that 60-day clearance period violated his rights under the CFRA. Court said, no, it didn't. First of all, you got all your leave under the CFRA. That's what the employer was obligated to do under CFRA. They didn't interfere with your leave. They didn't retaliate against you because you took your leave. What the employer did was it froze its 60-day absence removal, because as written, the 60-day was days of working. You had to have 60 days of working without any absentee problems. And if you did, then your demerits would be removed. And while you're on CFRA, you're not working. So what the employer did was just freeze frame. And when you come back to work, if you have good attendance for 60 days, your demerits will be removed. Another case involved abuse of FMLA, which I hate to say, but I know a lot of employers struggle with this. So in this situation, the Snyder case, the plaintiff had surgery on her foot, and she got certified by her doctor. It would take about 3 months to recover. So she's provided a full 3 months of FMLA leave. All of a sudden, while on leave, the employer starts to get information from other employees that they've seen plaintiff out walking around at a pool party, rumors that, you know, she's taking advantage of it, she's not recovering, she could come to work. So the employer hires a private investigator. They hire a private investigator while she's on leave and even after she returns from leave, because when she returned from leave, she was asking to leave a lot, saying that her ankle was painful and she couldn't work full time. So the private investigator does surveillance. They see her do things like climbing in and out of her Hummer SUV and walking around her backyard and downstairs and lifting and playing with children, getting manicures, mowing her lawn, all kinds of active activities, physical active activities that were contradictory to what she was telling the employee, that, you know, she couldn't even really walk around work and couldn't work full time. So they terminate her and she sues, saying she was sued in retaliation for exercising her rights under FMLA. DuPont files a motion, a summary judgment motion, to get the case kicked out of court, and the court grants the motion for summary judgment. You know, DuPont said, we're not terminating her because she, you know, took FMLA leave. We're terminating her because, you know, we have credible evidence that she's exploiting the system and she's lying to us about her status and ability to work. So the court agreed and dismissed her lawsuit. It's a good case for employers, but it comes with caveats and cautions. One, Snyder is an unpublished case, so it's limited to the facts of the case. It's not a precedential case. And second, there are other courts. There's another body of case law that have held that if an employer does surveillance on an employee while on leave, that could be deemed per se an adverse action, meaning per se an interference or retaliatory action because the person has exercised their rights to FMLA or CFRA leave. So you have to be very careful if you're going to go this route and actually hire a private investigator to do surveillance on an employee who's out on leave. Okay, here's another, I think, important case, because I think a lot of employers are utilizing third-party administrators now with respect to administering family and medical leaves. And in this case, the employer had a policy that required employees to contact a third-party claim administrator that they were contracting with to initiate and then administer FMLA leave. And the policy made clear that just submitting a doctor's note to HR was not going to automatically excuse any absence from work or designate the leave as FMLA protected. So this employee submitted some doctor's notes in 2015 for absences related to his own serious health condition and then also his daughter's serious health condition, and he asked to be provided FMLA leave. HR, who he submitted the doctor's notes to, said, look, we've told you submitting these notes is not sufficient. Our policy is clear. you have to work with our third-party claims administrator, and we're not going to just accept these, and we're going to count these as absences in our attendance policy. They're not protected absences under FMLA. Okay, he doesn't do anything at that point. He continues working, and then in 2016, he's got some absences from work, and he emails more doctor's notes to HR and tells HR that, you know, it's for his serious medical condition and he needs them to be protected, his absences to be protected under FMLA. They tell him, contact the claims administrator. He doesn't. And ultimately they sue him for violating the the attendance policy and the absence policy. And of course, he sues, claiming that it's a violation and interference with his FMLA rights. He says, look, I properly produced documents, medical notes from my doctor that put HR on notice that I have a qualifying FMLA condition, and therefore that was enough. I put the employer on notice that that was enough. I was entitled to FMLA, and I wasn't required to contact that third-party claim administrator. And the employer, because it's pretty settled in the Ninth Circuit, said, look, the Ninth Circuit has said that as long as we notify our employers that their claim administrator is the one that has to be contacted, they're the one that's going to administer any FMLA leave, then the employee has to do it. And if they don't, they're not going to be protected. The court agreed, said requiring that they deal with the administrator is not discriminatory, and they dismissed the employee's claim. Okay, we are moving out of the big world of FMLA and CFRA and now going with Ryan to talk about pregnancy disability leave.
Okay, thank you, Beth. Okay, so we're now going to address the pregnancy disability leave, which is a state law. This is a California only law. You'll see why that has some relevance, especially in regards to the overlap of when this leave can be used in tandem with or kind of stacked on top of the FMLA CFRA leave. But one of the biggest distinguishing features of PDL leave versus CFRA and FMLA is that there's no service requirement. As you know, for FMLA and CFRA, there has to be 12 months of prior employment. They have to have worked at least 1,250 hours in the previous 12 months. That doesn't exist for PDL. If they're hired, they qualify, provided the employer has 5 or more employees, full or part-time employees. And the leave that is required to provide here to the employees who qualify is 4 months of unpaid leave if the employee becomes disabled due to pregnancy, childbirth, or a related medical condition. And for when an employee is using this, they can use, you can require them to use their sick leave. We'll talk more about California paid sick leave momentarily. But the employee has to be given the option whether or not they want to elect to use any of their vacation or PTO that's available. And so pregnancy disability, getting back to what I said earlier, it runs concurrently with FMLA because again, FMLA doesn't really recognize PDL, but not with CFRA. They stack. So CFRA leave and PDL leave, an employee can be entitled to both. So what does it mean what qualifies an employee? How do you define whether an employee is disabled due to pregnancy? And as I mentioned before, this is very broadly defined. It's if any employee who is unable to work at all, to perform any of the essential functions of the job, or to perform those functions without undue risk to herself, her pregnancy, or other persons. And here's some examples of the types of limitations or applications that might be considered a disability under the PDL. Now, again, their employees are entitled up to 4 months. But how you calculate that is a function of what type of hours they typically work. And this is kind of a quick summary that essentially says it's linked to that. You get a pro rata share if you work part-time or if you work overtime generally. It kind of governs how that 4 months is going to be divvied out. An important feature of PDL as well is that the 4 months of PDL isn't a per year benefit, it's a per pregnancy benefit. There's, I guess, a chance that it could be 2 separate pregnancies within the same year where the employee could qualify for this leave. And this leave, like last, can be taken intermittently. Employers can't require that employees take it all out in one chunk. And also it can be taken before or after the birth of the child as needed. And as far as how incrementally the employer can kind of divvy this up, it can't be anything greater than the amount that the employer typically uses for other types of leave. We have an example here. If you count, the employer counts sick leave in 30-minute increments, but vacation at 1-hour increments, the employer then has to account for PDL leave in the increment of 30 minutes or less. So it's something to bear in mind. You can't arbitrarily assign a value that employees can only take it at a higher rate than that. So the employer also has an ongoing obligation to continue to provide, health benefits during the pregnancy disability leave. And like Beth mentioned, this can't be counted against the employer's obligation to maintain coverage under the FMLA or CFRA. They stack, they don't coincide. So the employer may, in some circumstances, need to maintain coverage for up to 7 months for a woman who takes PDL or FMLA CFRA leave. Because it's a function of state law, it's kind of this PDL grows out of CFRA. So the entitlement to these are separate and distinct. Again, they stack. The employer will need to provide both time frames of these health benefit continuation for qualifying employees. And kind of separate and apart from these leave requirements is the requirement to accommodate. We're going to talk a lot more about reasonable accommodation as we'll soon be getting into ADA and FEHA, but there's also an element of that required here for PDL leave. And again, we'll talk in far more depth about what reasonable accommodation, what qualifies for that, but generally that obligation exists here. And in the case of a pregnant employee, and someone who's taken leave on these grounds, accommodations are mandatory if the healthcare provider deems it medically advisable and the accommodation is reasonable. So, this is very, fact specific, totality of circumstances analysis. Again, we'll talk about whether it's reasonable, what causes undue hardship. But the more important part here is that this is, I guess, a far higher standard than the medically necessary FMLA standard. Right, so it only has to be medically advisable. So it's going to be a lot easier to hold that the accommodation should be required because it's simply advisable. So as far as reinstatement, so the employee has taken their leave, they're ready to come back to work. The employer cannot deny the reinstatement, even if the employer can show that preserving the job or duties would substantially undermine the ability to operate safely and efficiently. That's a pretty significant feature of this law. And the job features, when it comes to job search, when they return, if the employee for some reason can't return to the original position, they must be offered a comparable position. We're not going to get in depth about what that means exactly, but that's also kind of a defined term through case law and whatnot. But the employer has to offer that at the time of reinstatement or within 60 calendar days of the reinstatement date. And during that 60-day period, the employer has an obligation to provide a list of all available positions for that employee to select from. And that needs to be conveyed to them by letter, telephone, or email, or whatnot, so that the employee can make an informed decision as to their rights in that regard. Okay, so here we are, the bane of all employers' medical decisions. Leave as a reasonable accommodation under the ADA and FEHA. Now, most of the leave laws we've talked about so far, and again, all of these have been unpaid, and so is this one, but they all had kind of a defined period of time that the employee could take off, 4 months, a certain amount of weeks. This isn't like that. Here there's no hard and fast rule. This is kind of very squishy, this obligation that employers need to provide. So often, we'll get calls from clients and they say, oh, this employee has exhausted their FMLA leave and their CFRA leave. So now we can let them go because they're still not coming back to work. And often they're surprised to know that, no, now we have to do this reasonable accommodation analysis in addition to all that leave they just took. You can't just write them off. So this is a case-by-case analysis. This is a totality of circumstances type test that employers need to make in these circumstances. So if an additional accommodation is needed, is available, and can be provided without an undue hardship, the employer has an obligation to provide that. And sometimes in the case we're talking about now, a request for additional medical leave is very often the reasonable accommodation that might need to be required. To what extent is their absence or their continued absence from the place of employment, is that really causing undue hardship? And to what extent, can we replace this employee? What are our rights? But generally speaking, an indefinite leave of absence, by definition, is not considered reasonable under the law. So if an employee just leaves and doesn't show up, it's very hard to, or if not impossible, for most employers to accommodate that request, and courts have recognized that. An anticipated duration may be sufficiently definite. So if there is an expected return date, and often employers will see continued extended leave as they come out. But one thing that won't serve as a shield for employers against all of these is the attendance policy. The employer can't necessarily say, oh, this leave request violates our attendance policy, because the employer might be required to alter their attendance policy as a reasonable accommodation and to provide, flexible leaves of absence policies. So that, to the extent the reasonable accommodation conflicts with those. Okay, so undue hardship. So we mentioned an employer needs to provide reasonable accommodation provided it doesn't cause an undue hardship to the employer. Undue hardship is a term of art, and there's a body of case law that kind of defines specific circumstances as to what might be considered a hardship. But they look at really all the relevant circumstances, including the size of the employer. So obviously, if it's a very small employer and there's very few people to fill the position, it's going to be hard or impossible to provide a temporary position. Then that's more likely to be an undue hardship versus a very large employer that has kind of a revolving door of people coming in and out, and tons of people to fill the positions. But other considerations they look at are the other employee schedules they're affected. If it's causing other employees to have to work less desirable shifts or more often than they like to, that's considered in this analysis. The nature of the operation, right? To what extent is in-person presence required? To what extent, how important is this employee? Are they one of many, or is their position such that we need to have someone here in this position? These are all things the court will consider. But it's advisable to never be too quick to determine what an undue hardship is. Again, colloquially, you could say, oh yeah, all this caused an undue hardship. But again, the law has defined it very specifically. So it's always advisable to work with legal counsel whenever you're making that type of determination. So as far as what the courts are saying about the reasonable accommodation, for the sake of time, I won't get into too much depth here. But as I mentioned before here, the Ninth Circuit has said that an indefinite period of time is pretty much default not considered reasonable, but a finite period may be reasonable, even if it's really long. So even if an employee asks for a really long time off, you can't say, oh, it's just really long, ergo, this thing is unreasonable. There has to be that analysis as to whether it does in fact cause an undue hardship, because their courts have found that in certain circumstances, leaves up to and exceeding a year have been required, employers required to provide that reasonable accommodation. Again, within the ADA context, which is a little more employer friendly, an employee cannot repeatedly invoke leave as an accommodation where there are plausible reasons to believe that leave would not be effective, such as the fact that a prior leave was granted and was unsuccessful. So again, this comes back to the employees constantly taking leaves. Under the FEHA, it's not quite as easy. So we're saying this more for your own knowledge and enjoyment. but to the extent the fee hub provides a higher floor, you can't go below that. And the Nunes case here versus Walmart, again by the Ninth Circuit, the courts suggested that it might not be an undue hardship for an employer to hold a job open for a lengthy period of time where its own benefit policy allowed employees to take up to 1 year of leave, and it regularly hired seasonal employees to fill positions. So again, this shows the courts are going to look deep into the actual circumstances. So it's going to be hard for an employee to articulate and support their argument that, look, this would have caused undue hardship, where in another context for an employee who wasn't disabled, we gave them some lengthy leave, right? So they're going to look at all those types of circumstances. And then under FEHA, this just more or less summarizes what that standard is. Okay. This harkens back to what I mentioned earlier about medical certification under the FMLA and CFRA. Similarly, under FEHA, when you have these lengthy leave requests, the employer is entitled to obtain the medical certification. You can go back to that DFEH link we provided in this paperwork that shows where you can use for that. But it's a very similar process, very similar situation where the employer can submit this to the healthcare provider. And to determine things, including but not limited to the employee's disability or medical condition. And to the extent there's any question out there, the employer only wants to know about the disability to the extent it impacts the employment relationship, to the extent it impacts that. We don't want to go digging and find out all nooks and crannies about our employees' medical conditions. It'll be limited to the job, whether or not the employee can perform the essential functions of the job. Again, that certification, you're going to want to include the job description, which you've dutifully created at the beginning of their employment, not right before this process. What accommodations are recommended, what the employee has told them they need. You can pass it on to the medical provider, and you can seek, what's the anticipated duration of the need for the accommodation. Again, this looks a lot like what we talked about earlier. Word of caution, make sure you do not seek anything that can involve genetic information or that can be seen to involve that. In fact, include a disclosure saying do not give us anything about an employee's family history or medical or genetic information rather. And FEHA prohibits discrimination based on genetic information as well. And EEOC has a disclaimer you could include in your forms if you want to include that. So we recommend adding that as an addition to what you send over to the medical provider. And similarly to what I mentioned earlier, if the certification that you get back is insufficient or incomplete, you need to explain to the employee why that's the case, and you need to give them the opportunity to correct it, to fix that. If they don't fix it, then the remedy for the employer is they can require that the employee sees their own healthcare provider chosen by you. So again, it doesn't mean you can deny it outright. It requires the employer to do more. Okay, so now we're going to enter into our first paid leave requirement here. So California paid sick leave. This rolled out, I believe it was July 1st, 2015, and it broadly applies to all public and private employers in California, regardless of their size. Any employee who's worked for an employer for longer than 30 days qualifies for this sick leave. And it applies to full-time, part-time, temporary, out-of-state employees, all the above. There are certain exceptions. We won't go into depth, but if you have a collective bargaining agreement that has some contradictions, that could exempt them from the California paid sick leave. In addition, there's other special industry exemptions, the construction, healthcare, and airline industries, and the like that could potentially disqualify an employee from these types of benefits. So what does this leave look like? What amount do employees get? So, and there's different ways that that employer can have these accrue. They can do a lump sum, they can do an accrual. Under the statutory accrual, the employee is entitled to 1 hour per every 30 hours worked. And if there's different rates within 90 days before they take this paid sick leave, the employer has to pay at the regular rate of pay. And we're not going to get in depth of that. That's a whole other animal, but hopefully you know the difference between hourly rate and regular rate. But the paid sick leave needs to be paid out at the regular rate. Employers can also set up alternative accrual methods, provided that the employee accrues at least 24 hours of paid sick leave by the 120th day of employment. Again, the employee isn't entitled to use this right away, but they start accruing it right away. And there needs to be annual carryover. So you can't just whitewash it end of the year, you're back at zero. That's not the way this works. It accrues, but employers can and should include an accrual cap. And the cap can be at 48 hours, which, as you'll see, is much higher than the actual usage per year requirement. So 48 hours or 6 days. And for those working with in-home care providers, there's a separate standard for those. An additional, I guess I'd say the more simple way to distribute these paid sick leave is in a lump sum or front-loaded option, where there's no accrual, there's less administrative oversight, right? You don't need to track the hours and add that up. So there's some administrative ease with this option, but expect to pay out more leave over time because of it. Because obviously you're giving employees that full load right away, and they could use it right away and potentially leave, whereas they wouldn't have that option if you were tracking it by hour. And this is something different from we're going to talk about PTO and vacation. The accrued sick leave doesn't need to be paid out at termination. However, if an employee is terminated and rehired, they get to pick up whatever they didn't use. So that's another importance of maintaining these records, because an employee needs to be given that when they come back. And again, they can begin using this at their 90th day of employment. So it accrues right away, but they can't use it till the 90th day. It can be used. This gives you a description of what types of reasons they can use the sick leave. It's very broadly defined, and they can use it for these types of family members. It's not just for their own sick leave. It's for the care of their family members, which includes all of these individuals here. And employers can have a usage cap that can limit the use of sick pay to 24 hours or 3 days per year. And employers can set a reasonable minimum increment for usage. Obviously, you can't discriminate or retaliate against employee requests to take paid sick days. This applies to every every leave law we've talked about so far. Each one of these have a feature that adds a cause of action if there's any type of retaliation or adverse employment action that they suffer because of their requests for or usage of any of these leaves. As far as the paid sick leave, there's kind of a two-way notice requirement. The employee has obligations, the employer has obligations. The employee needs to provide reasonable advance notice if the leave is foreseeable or as soon as practicable. Obviously, sometimes it's not possible, but that's the employee's obligation. On the other hand, the employer needs to post the labor commissioner's paid sick leave notice, and usually, the conference room, wherever it is, you keep your posters. And also need to provide employees written notice of the amount of statutory paid sick leave that they personally have available. And this is typically done in itemized wage statements. You can also do it in separate writing, but it needs to be provided on that regular basis as well. Going back, because an employee can, once they're gone, if they get rehired, they get to obtain that leave that they didn't use. It's critical that the employers maintain all of the records, including their available sick leave, for at least 3 years. In addition, a lot of cities, we've identified several here, and municipalities have their own sick leave ordinances that go above and beyond the California sick leave requirements. So to the extent you have any offices or run the operations in one of these areas, be mindful of that. We're not going to have time to go through each of these today. And with that, I will pass the time back to Beth.
Thank you, Ryan. Thanks so much. I know we're coming up on time here. It's 11:04, so we're going to move pretty quickly. There are a whole host of other statutory leave entitlements for eligible employees under our labor code and other statutes in California. I'm just going to run through them as an overview here. So the first one is kin care. Sometimes a little confusing now that we have mandatory sick leave under the Healthy Workplaces, Healthy Families Act. But essentially it says that an employee can use up to 1/2 of what they would accrue in a year, right? The amount not less than what they'd accrue in the 6-month period. Over the years, the statute's been revised to say they can use kin care for the same reasons as they would use it under California's mandatory sick leave law, to care for a family member. The same definition is used in kin care as under mandatory sick leave. And then as of last year, the statute was also amended to say employees get the right to choose whether they're designating a day they take for sick leave as a sick leave day under the Healthy Workplace, Healthy Families Act, or for kin care. And, you know, you kind of wonder, well, what is this? Why do we even have it anymore? It seems like it's, you know, it's irrelevant, this kin care, because they get to take sick leave under the sick leave statutes to care for family members. But really it comes into play when an employer provides more sick leave benefits than the statute, the Healthy Workplaces, Healthy Families Act mandates, so that if they have sick leave available over and above that, they can utilize their rights under the kin care statute to use that leave to care for a family member. The other thing is there's a position out of the DLSC that if employers have a PTO policy rather than separate vacation sick leave policies, and that PTO policy does not at all differentiate between how much of the accrued PTO can be used for sick leave versus vacation, then for kin care purposes, the entire portion of PTO is considered when measuring the 1/2 usage for kin care. Organ and bone marrow donation leave. This is for employers with 15 or more employees. If an employee's worked for you for at least 90 days prior to the leave, and they're going to be a bone marrow donor or an organ donor, they can be entitled to this leave. This, like the paid sick leave that Ryan talked about, is paid leave. It's one of our few paid leave statutes in California. However, the employer can require that an employee who's going to be an organ donor use up to 2 weeks of any accrued vacation or PTO concurrently with their 30 days of organ donation leave. And if they're going to be a bone marrow donor, the employee can require that they use any accrued and unused PTO or vacation for the first 5 days, concurrently for the first 5 days of that leave. Now, okay, that's great. But what if you have employees who have no accrued PTO or vacation? Well, then you're paying for their organ donation and bone marrow donation leave if they are otherwise qualified. This is right of reinstatement leave, so they have to be reinstated to the same or equivalent position. We can't interfere or retaliate. As Ryan said, there's non-retaliation provisions in all of these statutes. We have to maintain their group health insurance. Also, under this statute, there's no break in service when they're on this leave. And so they don't have a break in service for their continued entitlement and accrual of salary adjustments, sick leave, vacation accrual, PTO, and so forth. It also doesn't run concurrently with FMLA and CFRA, and it can be taken intermittently. And not last year, 2 years ago, the statute was amended to just extend entitlement to organ donation leave, if necessary, by an employee for another 30 days in the 1-year period, but that is unpaid leave. And I think that's because that may be a little bit more of an involved situation, and so they may need more than that first 30 days of paid leave if they're donating an organ. Jury and witness duty leave applies to all employers in California. Employees can take unpaid leave if they are subpoenaed to serve on a jury or subpoenaed as a witness. There's no time restriction under the statute. Essentially, it's governed by the service, jury or witness service. They can choose to use concurrently vacation and PTO that they may have available. If an exempt employee is serving, then we're not going to deduct from their weekly salary if they perform some work sometime during that week. We can only deduct if they're out completely for a full week and perform no services for the employer. Voting, not really a leave, but it's kind of a 2-hour go vote kind of entitlement, and it applies to all employers, but it's limited. So this is only applicable if the employee does not have sufficient time outside his or her schedule to go to the polls and vote. And this should not come up all that often because the polls are open really, really early and they're open really, really late. And technically, this is also a paid leave, because if they give you notice that they're not able, based on their schedule, to go to the polls during their the time the polls are open, then they're entitled to take 2 hours paid to go vote. It should be at the beginning or the end of their regular shift, and they should give you no less than 2 days advance notice to do this. No retaliation, of course, if they exercise this right. But again, should really come up in very rare circumstances. Okay, domestic abuse and crime victim leave. So this applies to all employers when an employee is in need of time off to take care of legal proceedings related to some domestic violence or stalking or some other kind of abuse or crime. Those include situations like where they need to go and get a temporary restraining order or some other court assistance or attend court hearings. We need to accommodate them and provide them this unpaid time off to do it. If they have accrued vacation or PTO or sick leave, they can use it to be paid. So that's with respect to legal proceedings. For employers that have 25 or more employees, we also have to give them a time off if they need to pursue medical or safety services, psychological counseling, domestic programs, rape crisis, shelter services, and so forth. We had an amendment to this law a year or so ago that expanded the protections under the domestic abuse crime leave. It protects employees who are victims of a crime that have caused physical injury or mental injury and a threat of physical injury. An employee who's a victim of any form of domestic violence, sexual assault, stalking, or abuse, and an employee whose immediate family member is deceased as a direct result of a crime. And they need to take time off to deal with either legal issues or, as applicable, medical and kind of safety shelter issues. And immediate family member, as you can see, is defined very, very broadly. It could include somebody that's not technically related, but who they have an individual close relationship with. We have an obligation as employers to also do some accommodations, not just provide leave to these individuals, but accommodations in the workplace if they are subject to some of this assault and crime. You know, employers can even pursue a TRO on behalf of employees if there's a threat to safety of an employee or employees in the work site. But absent that, if an employee is being subjected to this kind of abuse and crime, we may need to, you know, adjust their shift, maybe change their telephone number if the person is calling their office number frequently, transferring them, and so forth. If somebody is needing leave or even an accommodation under this statute, we can request certain documentation to support the accommodation or leave. It is job protected leave with right of reinstatement. Employees, to the extent they can, should give employees advance notice if they need to be absent to take care of these issues. If it's not possible to give advance notice, then employers can ask for this documentation after the fact to support the absence. And there's a list here, and when it was amended, the statute as to what documentation would be sufficient, it added that any other form of documentation that reasonably verifies that the crime or abuse occurred is sufficient, including a written statement signed by the employee or the individual acting on behalf of the employee. And then, of course, we have to maintain employees' confidentiality and privacy in connection with these situations. The DIR has a notice because employers are obligated to notify employees of their rights established under these laws, and we give you the website here where you can go and obtain a copy of that notice. There's also another crime protection leave. This is sometimes referred to as felony crime victim leave. It applies to all employers, and eligible employees are those where they or their family member are victims of a violent or serious felony, or a felony that involves theft or embezzlement. This leave is limited specifically for the purpose of attending judicial proceedings related to the crime. It's unpaid. There's no length, or cap on the length in the statute. It really is governed by how long the judicial proceeding goes on, but employers can require documentation evidencing the judicial proceeding to support the leave. It is right of reinstatement, so it's protected, and of course, you cannot retaliate against an employee for taking the leave. School suspension leave applies to all employers. If a parent or a guardian of a child has some disciplinary action, including suspension, employees can take time off to appear. Oftentimes they get a notice from the school that they need to appear because their child's in trouble. Employees need to give reasonable notice to the employer that they need to go take care of this. It's unpaid, but it can be paid at the employer's discretion, and the employee can use any accrued vacation or PTO concurrently. There is right of reinstatement, and there's a willful refusal provision in there that says if an employer willfully refuses to provide the time to the employee, it could constitute a misdemeanor. School childcare, that's different than school discipline suspension. Suspension applies to all employers. This leave applies to 25 employees if they work at the same location. Now, that's different than other leave statutes that say how many employees have to work for the employer. They don't put the geographical limit on it. Here they do. This applies to an employer that has 25 or more employees at the same location. These eligible employees are parents or guardians, and that's a broadly defined term. It provides up to 40 hours of unpaid leave per calendar year for various child school or daycare activities. And parents can include grandparents, step-parents, foster parents, and anyone standing in what's called in loco parentis with the child, which means not related, but has essentially acted as the child's parent. And why can they take the leave? They can take the leave to, find and enroll children in school or childcare, participate in activities at school or in childcare, or to address certain emergencies that may exist at school or childcare. Now, it's 40 hours a calendar year. The employer can limit it to 8 hours a month, but the 8 hours a month cap or limitation does not apply if the purpose of the leave involves some form of emergency. It's unpaid. Again, employees can use concurrently accrued paid vacation or sick leave or PTO. Military spouse leave applies to employers with 25 or more employees, and eligible employees are those who work on average 20 hours a week, and they have a spouse or a registered domestic partner who's in the armed services, the military, and that person is coming home on leave from deployment. The employee can request to take 10 days of unpaid leave to spend time with that person while they're on leave. They can use vacation and PTO concurrently if they have it available. Employers are allowed to ask for documentation evidencing that the person is on leave from deployment to support the leave. Civil Air Patrol applies to employers with 15 or more employees. If an employee is in the Civil Air Patrol, the California Civil Air Patrol, they can take up to 10 days of unpaid leave to perform their services. Again, if they've got PTO or vacation, they can take it concurrently, and employers can request documentation to support that they actually are taking the leave to fulfill their duties in Civil Air Patrol. Leave for emergency personnel. These are employees who are either paid or volunteer, firefighters, private, police enforcement, paramedics, any kind of emergency rescue personnel. If you have employees who do participate as emergency rescue personnel, you should ask them to kind of let you know ahead of time, even when they're not requesting leave, just so you know it's a potential that they may be called away to perform duties at some point, particularly in California, where we have fire season and a lot of volunteer firefighters are called off to go fight the fires every year. There's no cap on the leave if they're performing the services. Again, it's governed by the emergency that they are assisting with. We can't discriminate or retaliate against them for taking the leave. And if we have 50 or more employees, in addition to providing them the leave to actually go participate in emergency services, we also have to grant these same employees up to 14 days of unpaid leave each year so that they can do their training, right? So they can stay abreast of their training so that they're ready and prepared when an emergency happens. Okay, this is, it's not really a leave, it's more of an accommodation, but we call it accommodation leave with respect to an employee who discloses to you that they may have a literacy program. If you have 25 or more employees, employees can ask to take unpaid leave to participate in some literacy education program. You have to engage in the interactive process, see if you can reasonably accommodate them to take that time off. If they're for some reason can't attend it after their regular work hours. We have to be very careful here that we safeguard their privacy. We cannot disclose or discuss the fact they've told us that they have a literacy problem. We also cannot terminate or retaliate against them for disclosing it or for taking time off to learn to read. It's unpaid. They can choose to use accrued vacation or PTO if they have it concurrently. And then the same, very similar, is a kind of an accommodation leave if an employee comes to you and discloses they have a substance or alcohol abuse problem and they want to go in to rehab and get treatment. If you have 25 or more employees and somebody discloses this to you, and requests time to do it, you have to engage in an interactive process to see if you can reasonably accommodate them. Again, a discussion should be had about why it is they need time off. Are they not able to schedule treatment after their regular hours? Often in a rehab program, they may be going into inpatient rehab where they're there for an extended period of time, and so they would need the time off. They can use available sick leave, PTO, vacation concurrently. Here, we also have to safeguard their privacy with respect to their disclosure to us that they have a substance or alcohol abuse problem. Okay, we're going to turn it back over to Ryan and really move like the wind.
Yes, let me get control here. When we promise we're going to give you a comprehensive overview, you are getting a comprehensive overview, and we're running up against the clock. So we're going to race through some of these last ones. So these are some discretionary leaves, meaning an employer does not have to provide them, but if they do, it's be cautious about what type of benefits and what type of rights you're giving to the employee. This includes the most prominent one is vacation or PTO. So vacation, again, there's no obligation to provide this to an employer, but to an employee. But once they do, it's considered almost like a contractual right. So everything so before is statutory. They get it regardless of whether you want to or not. Once an employee's been given their vacation, PTO, it's a vested right. It has to be paid out to them. That includes if they're terminated, they need to be paid out all accrued vacation leave. Employers can institute, use it or lose it. So once they've accrued it, they get it. You can't pull it back. You can have reasonable caps though. And one of the biggest problems we commonly see with this is where employers don't provide a clear cap as to how much can be accrued. Okay, so some other similar and related leaves is workers' compensation. As you know, this is a whole separate animal, typically handled by your insurance provider, but employees can take leave and they could obtain during that time not only a leave, but wage replacement. This is what's called temporary disability. So under workers' compensation, injured employees who are injured in the course of performance of their duties can obtain permanent disability, which is compensation for whatever long-term effects of that problem have caused them, but also this temporary disability, TD, where they can get paid a portion of or all of their wages in some instances, even though they can't work because of the injury and the recuperation required. All California employers are required to provide this, to provide, obviously required to have valid workers' compensation insurance and all that, separate violations attached if that's not provided. After someone comes back or they're considered able to work again, there's no obligation to reinstitute an employee. Again, this is based on the workers' compensation regime. If the employee's disability really kind of prevents them from performing the essential functions of their job, or if the employee indicates that they don't want to return to work, which isn't too uncommon, or if the position no longer exists, if the employee is no longer qualified for the position. If, again, I mentioned that they can't perform the essential functions of their job, or if they're returning, given their current state, would cause a serious threat to the health or safety of themselves, of other employees, sorry. And the final one is if the employee qualifies and elects to take vocational rehabilitation instead. However, that's not the end of it. This is a web of leave laws, right? So you also have to do the ADA FEHA analysis and a reasonable accommodation. So that always needs to be done at the tail end of this. And obviously consulting with counsel is advisable in that regard. The common claim that we get here is a 132A claim, which is essentially retaliation. Common sense at this stage, don't just comply with those obligations as soon as benefits that were supposed to be provided aren't provided while employees on leave due to the workers' compensation claim. That could give them grounds to file and prevail in a 132A retaliation claim. And obviously termination is permitted under Workers' Comp Act. Even if it's permitted there, it could violate one of the many other laws we've already talked about today. Paid family leave, we're not going to go into the depth of this because this is administered by the EDD. The employer isn't as an active participant in this regard. The determination is made by the EDD. So for sake of time, we'll kind of breeze through that, but you have it there if you need to refer to it. Same applies to state disability. And with that, I'll turn it back to Beth to talk about the importance of good documentation.
Thank you, Ryan. We've got 3 minutes. And we're just going to fly like the wind to just talk about some practical issues here. So you should request documentation to support an employee's absence from work, not just FMLA medical certifications, but whenever an employee tells you, I need to be out for an extended period of time, you then need to start thinking, what is it potentially that this employee may be eligible for? What should I be designating this leave? And what information do I need to reach that reasonable finding? It is not okay, and you should not just always accept employees turning in doctor's notes that say something like, Sally's under my care and needs to be out for 3 weeks. That doctor doesn't get to make the determination that Sally's entitled to be out for 3 weeks. And that doctor doesn't know and doesn't care what potential statutory leave may be applicable in the situation. And so while some statutes, permit you to get medical certifications, no statutes mandate that employees turn in medical certifications and documents. It's the employer's right to ask for them. So you should always ask for documentation to support the need for an extended leave of absence. Now, the caveat is don't do that within the first few days of sick leave under the Healthy Workplace, Healthy Families Act, because employees are allowed to choose to take those sick days, up to 3 in a year, and we can't really stop them from choosing to use that. But any other absence, you have the right to get documentation to support the absence. What happens is we have clients call us and they say, well, the employee's been absent for, a long period of time. And well, we just don't know what to do at this point. And I think we're ready to just terminate. And we'll ask the question, okay, well, what kind of leave are they on? What did you designate the leave? And we get the response like, well, we just accepted the doctor's note, or we just put them on a quote unquote personal leave of absence. Well, this is not good, not good. We as employers, we have to do the hard work, right? FMLA and CFRA actually impose an obligation on employers to designate and put it in writing and give that designation to an employee if they are qualified for FMLA or CFRA, or even if they're not, we have to designate it. So we should be designating and documenting every kind of leave that an employee is on, all those leaves we just went over. And if we do that, it will do a couple of things. It will document that the employer is complying with whatever the applicable leave or accommodation law is. And it will also document any limitations on an employee's entitlement under an applicable law. It helps make things clear so there aren't open-ended absences and ambiguities in what the employee status is. So we have to do the hard work as employers. We have to evaluate every situation and determine why is the employee absent? What documents do we need to understand why the employee is absent? Once we have that, what particular leave laws may their absence fall under, or accommodation laws may their absence fall under? And then we need to create documentation that we make very clear, we are designating your leave as X, and here's what we understand it means. You will be out from such date to such date. You're going to turn in a medical certification to support that, and so forth. It takes time. A lot of employers don't like to do it. Sometimes it gets a little difficult. If it gets difficult, work with your legal counsel. Okay, final topic, reducing the risk potentially if we say we're not going to reinstate or we're going to terminate an employee who's exercised their right to a leave or an accommodation leave. All the leave statutes and accommodation laws have anti-retaliation provisions, and most of the leave statutes have right of reinstatement provisions. Matter of fact, all the leave statutes do, with certain exceptions, and then the accommodation laws, essentially the case law says they have right of reinstatement. So we always have to make sure as employers that when we're making a decision, including a decision not to reinstate or to terminate employment, that it's based on a legitimate reason, a legitimate business reason, and it's not retaliatory. It is not because they exercise their right under a leave or accommodation statute. So if we fail to reinstate or terminate an employee during leave or upon completion of the leave, we know that there could be an inference because of the proximity in time, they're engaged in a protected activity. There could be an inference that we terminated them because they exercised their right? They exercised and engaged in a protected activity. But we also know that employees don't have any greater rights to continued employment, especially at-will employees, while they're on leave than they would have had while they were working. And so again, if we have a reduction in force or we've discovered something during the leave and we can document it, we have tangible examples of serious performance or serious policy violations or misconduct, we can still take action. If we would have terminated them had they been continued to work, we can still terminate them even though they're on leave. But it's a very risky situation, right? Because of the fact that they are engaged in protected activity. And so we advise that you work with your legal counsel before you actually deny reinstatement or terminate employment. And that brings us to the end. We are over by a few minutes, so I think we likely don't have time, but I'm going to turn it back to Ryan for some closing.
Yeah, thank you all for joining us. Thank you, Beth. And if anyone has not received their packet, please reach out to Ramona. She'll get that to you. Just wanted to give you all a heads up on some of our upcoming webinars and training. If you want to take part in some of these, the first one we have coming up on September 21st are 10 things you should be doing before the employment relationship ends. So that's going to be a good one. That'll be another 2-hour presentation. Another one coming on November 9th is the top 10 developments in employment law in California, getting ready for the year's end and making sure you're compliant with the new year. And then on December 8th is our mandatory, moving a little fast here, mandatory sexual harassment prevention training. So again, you can reach out to Ramona if you'd like to register for any of those. And again, thank you all for joining us. Sorry we didn't have time for Q&A today. We had a lot of material to cover. I tried to answer some of the questions in the box as they came up, but wasn't able to get to all of them. At any rate, feel free to reach out to either Beth or myself if you have any questions specifically, and we'd be happy to help you.
Thank you, everyone.
Thank you.